Whenever you're ready. How much time would you like for rebuttal?
Your Honor, I'd like to reserve 3 minutes for rebuttal.
Minutes. Okay, whenever you're ready.
May it please the Court. Robert Flavel on behalf of the appellant, Cristobal Colon.
Can you speak up a little bit?
I'm sorry, Your
Can
Honor.
you speak up just a little bit?
Absolutely.
Thank you.
We are here on appeal from a final judgment of foreclosure, summary judgment of foreclosure. The basis of the appeal is that the plaintiff or the appellee failed to submit competent summary judgment evidence.
Let me ask, just to clear up one thing in my mind. Was the actual breach letter, acceleration letter, was it tendered at the summary judgment hearing?
It was not, Your Honor.
Okay, because and you're Mr. Flavel, right?
That's correct, Your Honor.
There was a motion for rehearing that you filed in the circuit court at paragraph 3. You indicated during the summary judgment hearing, plaintiff produced a copy of the breach letter, but then you say, but did not authenticate it by affidavit or by other means, that part I believe is what your argument is today.
Correct, Your Honor. I do not believe, I was not present at the summary judgment hearing itself due to a conflict. I have a copy of the transcript. My understanding, the letter was not produced at the hearing. It was simply referred to at the hearing. The letter was never filed with the court. The letter was never attached to a motion for...
Yeah, there was a response to a request to produce.
That's correct, Your Honor.
It makes reference to attaching the letter to the request to produce.
There was a letter that was produced pursuant to a discovery request and a request for production.
Attached to that request to produce.
Correct, Your Honor.
And that request to produce, the original was filed with the clerk of the court.
The response to the request for production was filed with the court. The letter itself was not. All the documents were not filed with the court.
They were not attached to the request to produce?
Not to my knowledge, no, Your Honor.
Okay.
Even if they were.
Well, I understand that your position, and I follow your position, that even if it was, that doesn't meet the requirements, and it's not good summary judgment evidence, it's not competent evidence under 1.510 because it's not authenticated, and there is numerous cases that predate this case from all different districts that make that fairly clear.
Exactly, Your Honor. This is not a case of first impression. This is pretty well established. We raise an affirmative defense, failure to comply with paragraphs 15 and 22 of the mortgage regarding notice of acceleration, and we specifically deny ever receiving any notice. That affirmative defense was never challenged. There was no reply filed. There was no motion to strike. The motion for summary judgment is silent as to the condition preceding argument. The affidavit of indebtedness is silent as to the condition preceding argument. The letter was never attached to the motion for summary judgment or to any affidavit.
Can you respond to Appellee's argument that, as to your affirmative defense, that the letter was never received, that you're not required, the proof of receipt is not what was required, it's proof of mailing, I believe.
We're not attempting to allege that proof of receipt is what's necessary to comply with the condition preceding. That was simply inserted as in support of the allegation that the requirements of paragraph 15 and 22 were not complied with. We specifically cite to the provisions. This is foreclosure law. It's not rocket science, for lack of a better word. It's pretty well established. As Your Honor stated, the courts have made it very clear. This is a recognized affirmative defense. It requires some specificity. We specifically refer to the paragraphs of the mortgage that we're saying have not been complied with. And then the court says, look, you want to get around this affirmative defense, you assert a letter that's properly authenticated pursuant to the rules of evidence for summary judgment. It needs to be an affidavit saying that by a record custodian or someone with personal knowledge. And then the burden shifts to the non-movement party to show that there remains an issue of material fact. That didn't occur here. There was no notice that anyone was challenging the affirmative defense until the day of the hearing. The motion is silent as to that. The motion raises only the issue of standing, and it speaks about a pro se defendant. It's not even applicable to this case. And yet, at the hearing, for the first time, they bring up the issue that somehow our affirmative defense is insufficient. There's no finding that it was insufficient. The affirmative defense was never stricken. No evidence was ever filed in support of, to refute the affirmative defense. I mean, this is relatively basic procedure. And I'm at a loss as to why we have to continue going through these motions. But in any case, here we are. And in all candor to the court, we cited Bryson and Morrison in our brief, and I understand in shepherdizing these cases in preparation for the hearing last night that this court has issued another case very recently, directly in point, but in candor was not listed in mine, which is the Cross case, which basically stands for the same proposition, that you cannot rely on an unauthenticated letter to refute the affirmative defense of condition precedent. And as far as the other argument raised at the hearing, that we failed to submit any evidence, we're not required to submit an affidavit in opposition until the party meets its burden, and that obviously did not occur here. Unless the court has some other questions for me, I'm prepared to sit down and reserve the rest of my time for rebuttal.
You have 13 minutes and some change. All right.
Thank you, Judge.
Excuse me, Your Honors. May it please the court, counsel. Charles Gufford on behalf of the Appellee, Your Honor. Your Honor, to go into the argument, I must first concede. I do not believe that the breach letter was filed. I have reviewed the court docket, although it does say it's attached. I could not find it myself based on the record that's before the court.
Okay, so it's never was filed below. So if you assume that we think that the affirmative defense is sufficiently put you on notice as specific conditions, regardless of that last sentence about whether they received or didn't receive it, if we think that the affirmative defense is pled as sufficient, isn't it fairly clear then with the legion of the case law, Bryson, DeSalvo, Morrison, that you have it's an unauthenticated document that exists. I know it's referenced in the request to produce, or response request produced in the interrogatories, but it's not presented.
Correct, unless the motion for rehearing, which I couldn't.
But even if it was presented, it was unauthenticated.
Correct, Your Honor, you are correct.
And then as to the fact that it was in the verified amended complaint, you generally pled the conditions preceding were met, which is fine under the rule. But the affidavit or the verification is not based on personal knowledge, but it is based on information and belief that the 4th DCA in Lindgren has said that's not sufficient for summary judgment evidence.
I agree with that also, Your Honor.
What else you got there?
The 5th DCA case also, and I think Helping Hands also indicated that also. But I think the mainstay, going to the backup argument, is the insufficiency not only of the defense pled, but also of the fact that they did not deny the conditions precedent with specificity under Rule 1.120.
But they raised it as an affirmative defense. They denied generally the complaint, the paragraph 5 or whatever number, but then they asserted as an affirmative defense, putting you on notice saying, Condition 22, you've not complied with Condition 22, the notice requirements prior to accelerating. And I know let me ask it differently. If they left the last sentence off of their second paragraph, second affirmative defense about whether they received notice, then you're really out of luck, right?
There is an argument both ways, Your Honor. I think because this court in the Morrison matter also found that, but the Morrison matter, the defendant specifically cited to the elements contained in the paragraph that the plaintiff failed to comply with.
Well, what would that be? Well, let's assume that he never actually got the letter, so how could he respond to the...
We could look at the mortgage, because the mortgage says that if you never got the letter, the mortgage dictates under paragraph 22 what elements you're supposed to meet.
Did you in your complaint allege anything more than all conditions precedent have been complied with?
No, sir, no, Your Honor, we have not.
You didn't allege, we sent a letter as required by paragraph 22 of the mortgage, et cetera. You didn't go into all that.
No, sir.
Any more than
What's
they
required
did.
under Rule 1.120.
So it does seem like you can't require them to be more specific than you're required to be. That you allege generally,
But I'm allowed to, Your Honor.
we've complied with the well, affirmative defenses have to be pled with the same specificity as a complaint. And so, but we're dealing with two different things. One is a response to your general allegation that we complied with conditions precedent. And they generally said, we don't know, and so we deny.
Well,
They're not required to say anything more than we admit, we deny, or we don't know, so we're denying.
Well, then I don't understand then how the court's going to rectify then under the fact that, under the averments, when they're saying that to the paragraph 7 in our complaint, which we can plead generality, that conditions were all met, that they don't come back and say there, we deny that you made it based
So
on...
they have to say it twice?
Well, one's based on the affirmative defense and one's based on the other. I think you can read them apart, Your Honor.
Okay, so they raise in their affirmative defense, yes, you've alleged that, but you haven't complied with it, and here's how you specifically haven't complied with it, so they specifically address it. I mean, it seems like we're splitting hairs in your view. I mean, they put you on notice with their pleading, saying, you've not met your condition precedent because paragraph 22 has not been complied with. That then shifts the burden to you on a summary judgment to negate that because it's legally sufficient.
I would argue that it's not legally sufficient, based on the fact, and this is the reason why, because some of the progeny that the opposing counsel cited in the court is also relying, I feel, and even out of the first DCA, the Playa matter, I have the affirmative defense. They cited it with specificity in their affirmative defense. They went through and cited each and every element that the plaintiff did not comply with.
Well, I'm not, so let's say hypothetically there never was a letter sent.
Okay.
And so his affirmative defense is, you've not complied with paragraph 22, sending the notice, we've never gotten it. You're saying that they should then
well, in this case,
proceed further on their affirmative defense and say, and paragraph 22 requires you to do A, B, C, D, and E?
well, I mean,
Zero sense to me.
well, I think the other issue is that if you're tailoring your defense to paragraph 22, which they did, you have to use the right line correctly, and receiving it is not in the mortgage. I mean, it even cites to the note paragraph, which doesn't even require notice to be sent at all. It's a may language. So I understand, I think the court's wrestling with the actual specificity. Apologize, Your Honor. But it's our standpoint that he was not, and that the last line, even when he said specifically receiving it, is in contravention not only to paragraph 22, but also...
Basically, your argument comes down to the paragraph 22, excuse me, their affirmative defense relating to paragraph 22 was as a matter of law insufficient, so you didn't have any duty to rebut it.
Well, at that point in time, I think there's a progeny of cases that I can cite to the court too that says there's no reason that it's deemed denied once filed. You don't need to reply to it.
No, I understand, but you still have to, one of the things that you have to prove since they denied your allegation because they didn't have knowledge, they denied your allegation as to conditions precedent being complied with. Do you agree that at the summary judgment hearing, you had an obligation to demonstrate with appropriate summary judgment evidence that you had in fact complied with conditions precedent?
Yes and no, Your Honor. I think, if played correctly, I know I'm splitting hairs.
Well, let's assume they had raised no affirmative defenses at all. They simply said, we deny that you have complied with your conditions precedent. Now, at summary judgment hearing, do you, in the face of that, no affirmative defenses, simply a denial, we deny because of, we deny or lack of knowledge that you've complied with conditions precedent. Do you have the burden then of demonstrating to the court that you have in fact complied with conditions precedent?
Yes, Your Honor.
Okay. And so if we stopped our analysis there, do you agree that you didn't meet that burden at the summary judgment hearing?
Yes, Your Honor.
Okay. So why isn't that then the end of the discussion?
Because I think, based on the interpretation, that what they denied wasn't done with specificity. And the court concluded that I'm interpreting the rule wrong.
But I guess the question is, if they didn't even have the affirmative defense, and they simply denied that all conditions precedent had been met, and you've just said that that at the summary judgment hearing, not enough evidence was put forth to show that all conditions precedent had been met, then why are we here? I guess is the question.
And I think it's an excellent question by the court. I think the way I interpreted it was, I'm looking at the Second District Court of Appeals case. It's a Cook v. Insurance Company of North America, Your Honor, cited at 652 Southern 2nd, 1154. And in that case, and I quote the court, INA never pleaded a condition precedent with specificity and particularity necessary to create an issue for review. In other words, they denied it generally. They never said with specificity in their avertment to paragraph 7 when we say this complaint, what we didn't do. So therefore, the court went on to say, if I may, if a defendant wishes to deny such performance, the denial must be alleged specifically and with particularity for Rule of Civil Procedure 1.120C. In this case, Mr. Cook alleged compliance with all conditions precedent in general terms. INA denied these allegations in general terms. It never pleaded any of the issues raised in its motion for directed verdict. So I guess what I'm asking the court is to look at it separately. We have the avertments, which were not pleaded to explicitly, specifically based on 1.120, and then we have the affirmative defense, which looked at, I believe, is legally insufficient.
How about this, the 900-pound gorilla here now? Why don't you all just simply, when you file motions for summary judgment and conditions preceding are raised, simply have whoever's signing the affidavit verify under oath these are the documents? I mean, you're talking to a recent circuit judge who was trying foreclosure cases in the height of 2008 and 9 when it was coming down the pipe, and we had these ad nauseum conversations. It's like, why are you guys you could make this so easy, and then if you've done it, then they can respond to however they need to respond to it. Instead, you've got a complaint here that apparently, according to your allegations, these people they've been in default for 5 years, and if it goes poorly for you today, then your client's got to wait for an opinion to come out, and then you got to go through the process again. I mean, it seems pointless.
I don't disagree with you, Your Honor, at all. And I can tell you, this is an older case. There are affidavits now that are coming out by my clients and other entities that do specify not only that conditions have been complied with, but also attach a breach letter and authenticate this. It's a well-played issue. I just think it comes down to whether he had to plead it with specificity on the avertment and whether that defense itself is legally sufficient. Because, again, no facts pled with that, Your Honor. It's literally a denial.
Let me ask you, doesn't the affirmative defense of which you're questioning here today, doesn't it track the affirmative defense that was raised and asserted in DeSalvo, which I believe it was the 4th DCA or 2nd DCA said was fine?
It did, Your Honor, but obviously the court's not bound by that.
I understand that, but I mean, this is not a...
But it's in contravention to Morrison, which the court did find, and in that case, the defendant did cite it with specificity and particularity, and raised facts to support the defense, which is required, which in this case we do not have, I don't believe, because he merely gave a denial of receiving it, and receiving it is not the test, obviously.
Well, he didn't give a denial in his answer. He did in his affirmative defenses. Denial of...
Well, I'm calling it a denial.
Receiving it.
Correct. I'm calling it a denial in the sense...
But as to your general allegation that conditions precedent have been satisfied, he pled without knowledge, so we deny.
If I may, Your Honor, I believe so, but let me just make sure before I agree, Your Honor.
Well, he either denied it or he pled without knowledge. I don't remember which one, but...
He didn't admit it.
No, that's correct. No, I agree. I'm not trying to split hairs.
Bottom line to me, it comes down to if they had raised no affirmative defense at all and just generally denied it, we both agreed that you would have had to demonstrate compliance with paragraph 22, and it wasn't done. And I understand your argument, but I'm having a hard time getting past that point.
And I do too, I think I think the benefit of this would be, is something that comes down, and obviously this is me wanting something, obviously it doesn't mean it's going to be granted, but saying, this is what a defendant has to do to allege this defense appropriately. I mean, we get these
But this case is
boilerplate
really about...
defenses all the time.
But this case is really about what plaintiffs have to do in order to meet the burden of summary judgment. The defendant doesn't have to do anything.
Correct, Your Honor, Jackson, but I think there's also, we're dealing with not only if he had or had appropriately asserted affirmative defense, so I think it falls on both sides. Not only what plaintiff's counsel has to do to appropriately present summary judgment evidence and get judgment, but also when confronted with the issue of a legally sufficient defense under a summary final judgment. Either we have to disprove the allegations or facts that are presented, or get the court to find that they're legally insufficient.
But again, if they say you didn't comply with paragraph 22, you didn't give the notice under paragraph 22, and we've never gotten it, you seem to be saying that that's insufficient because they're not telling you what you've not complied with under paragraph 22, whether it was you didn't give a proper number of days to rectify the default or the amount, and if they don't have it in the first place, how do they then specify for you what is wrong in a letter that they haven't seen?
Well, I think you can say, we deny that you complied with each and every portion of the notice requirements contained in paragraph 20.
Because we've never seen it, so we don't know what you've done. And I mean...
But you can still say it with some specificity, saying...
How can he say it as an officer of the court filing a pleading saying you've not complied with something that he's never seen? He's saying, well, you didn't do A, you did B, you didn't do C. How could he do that?
Well, if his client tells him that I never got it,
Yeah.
and obviously looking at paragraph 22, one can gain, if I never received it, you never complied with how many paragraphs? If there's 1 through 100 or 2 through 100?
Isn't that kind of common sense then? If he says, I've never seen it, so I can't really comment about if you've complied with A and B and D, but not C and E, how can he say that? And if he says, I haven't seen it, that kind of puts you on notice that it needs to be shown through an authenticated, proper, competent summary judgment evidence that says this, and then, I guess, when you do that, he can ask to amend his affirmative defense, saying, okay, now that you've done that, and I've got the summary judgment, and the hearing's 28 days from now, I can file an affidavit or a motion to amend, saying, okay, I see that, but he's not complied with D and E. So, Judge, may I amend my affirmative defense, which a trial judge should do that at the stage of the case, so then you are properly framing the issues, and then you can discuss it. But he doesn't have the benefit of doing that in this case, because by your own candid concession, it was never filed.
Correct. That's correct. I understand.
It's kind of a catch-22, it seems like.
It is a rock and a hard place. I'm not differentiating with the court. Is there anything else I can answer?
Any questions?
Thank you.
Okay,
Thank you, Your Honor. If it pleases the court. Thank you.
Thank you.
Any rebuttal?
Very briefly, Your Honors, I don't think I have much to add. I believe the court has an understanding of the issues here, unless you have any additional questions for me. With all due respect to opposing counsel, plaintiff is engaging in sophistry in an attempt to move the burden. This is basic summary judgment practice. There's a very well-established procedure what needs to be done, and what they're trying to do is compensate for their failure to do that. The court in Samaru rejected this same argument by the same plaintiff's counsel. In Samaru, they said, the purpose of the pleading with specificity is to put the other side on notice. If we plead failure to comply with condition precedent pursuant to 2 specific paragraphs of the mortgage, that's sufficient to put everyone on notice what we're talking about. It's not unnamed notices or innumerable paragraphs. This is exactly what we're talking about. We deny ever receiving it. It hasn't been filed with the court. If you file it and authenticate it, we can then respond to the actual contents of the letter. But until that point, we're They're just trying to shift their own burden. This is a summary judgment proceeding. This is the denial of a defendant's right to trial. The burden is on the moving party. And what they constantly try to do is shift the burden to the non-moving party because it compensates for their own failures. Thank you.
Thank you. All right, we'll take our mid-morning break and